Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs' internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts, and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA, or Latin America to learn how to manage your IP assets and expand your business successfully.
Good afternoon. Welcome and thank you to each and every one of you for being here with us today for this webinar on new technologies in Singapore. What is the role of intellectual property? This webinar is a joint effort between European Chamber of Commerce and Southeast Asia IP SME Helpdesk. I hope you enjoy this webinar, and now I will pass the time on to our moderator today, Mr. Anan Sivananthan, who is from Bird. So now, Mr. Anan, please.
Hello, everyone. Good morning for those of you in Europe. Good afternoon for those of you in, the Asia Pacific region. And if anybody is dialing in from North or South America, good evening. Thank you guys for joining us. I think we are promised a very exciting webinar today. A couple of very interesting speakers, and you would have seen their names, and I will be introducing each of them separately later on. This thing about new technologies in Singapore, and I think speaking from my own experience, I'm a lawyer I'm an IP lawyer in a firm here in Singapore, and I've been practicing IP for, close to 30 years. Don't ask me my age. And in the 90s, I worked in a law firm here, and I would say that the kind of IP we practiced was bread and butter stuff, stuff that everybody's very familiar with. And then in the year 2000, I went in-house to join a tech company. And it was in the next 17 years that I really saw the emergence of new technologies, and I think even today, technologies are becoming even newer. The more interesting stuff is being developed. And in 5 years ago, I went back to a law firm, Bird, and it's fascinating to see again the amazing growth and development in this space of technology, not just in the traditional technology spaces that we're all familiar with, your audio and graphics and so on, but also even in the pharmaceutical industry. Medical technology has gone so far ahead, stuff that's out there in the digital world. And I think some of the speakers will be touching on some fascinating developments in the fields of AI, and then there's NFTs and all kinds of interesting stuff. So we are promised some very interesting speeches today. But before we jump to the speakers, we will first kick off with a discussion or a brief statement from the IP SME Helpdesk. And with that, I'd like to introduce from the SME IP Helpdesk, Mr. Benoit Tardy. Benoit, over to you.
Yes, thank you very much for a quick introduction, Anan. Very happy to be here. Today I will just present quickly, well, we already broadcasted a video of the International IP Helpdesk, but here we are talking about Southeast Asia IP SME Helpdesk. So basically, who are we? We are a European Commission funded initiative, and we are here to help European SMEs, small, medium size enterprises, to protect and enforce their intellectual property rights for a very specific region. It's Southeast Asia. We also help associations and clusters helping themselves, these SMEs. The very important things to remember is that all the services that we offer are related to IP and are free of charge. So here on this slide, you can see most of the services that we offer. The main ones, so you have the inquiry helpline. Basically, you can write any type of questions related to IP in Southeast Asia, and I will answer it within 3 days, working days. You have a very nice website with newsletters, a lot of publication on it. We also offer webinars and e-learning modules. We also have 2 interesting tools. One is diagnostic tool and the other is the cost tool. Everything is on the website. We'll share again the link to our website. And then the most interesting parts are the trainings and workshops, either on-site or virtual. And last but not least, the amazing guides and fact sheets that we have. They are in English, quite simple to read, can be downloaded on the website. And I wanted to highlight two publications that we have. One is covering Singapore, so you have basically all the IPR covered, and the other is super recent one. It's covering all issues and all the challenges, how to protect some aspects of IP when you are dealing with artificial intelligence. So we are each time trying to draft and publish new guides. So just stay put and subscribe to the newsletter. Now, just before jumping into the real core topic with Yeng just after me, we have a poll in order to assess a bit your IP knowledge today. And I'm warning you that it will be repeated the same 2 questions by the end of the webinar today. So just here's the question. The first one: in Singapore, I can register my copyright before the Copyright Office. Is it true? Is it false? It's a single choice answer. And I would read the second one and give you then approx 30 seconds to answer to both questions. The second question is: new technologies using artificial intelligence and machine learning can be protected by intellectual property. Is it true? Is it false? We will have more information, maybe some comments from our speakers. And normally you should have the answers during this webinar. Maybe you already know, but well, let's see then the results. Okay, well, I hand it back to Anan, if she wants to introduce the next speaker, and we'll come back to this poll later on to see if there are any new results. Thank you. Anan, you were muted. Yeah.
Very tricky questions there. Thank you, Benoit. Okay, so without further ado, we're going to jump into the presentations from our three speakers. The first of which is Chan Yeng. She has quite an interesting history in the IP space, including some time working in a firm in Myanmar. So I guess she can share a little bit about all of that. But she's got roughly 13 years of experience in the IP space with a chemical engineering background, working at a couple of law firms, heading up IP practices. And she's got a very interesting presentation. And I'd like to introduce Yeng. Take it away.
Thank you so much. Thanks, Benoit, Anan, and Prasad for the introductions. I feel a little stressed because I think my presentation is supposed to educate the audience, and hopefully after my presentation, the answers to the first two questions will change slightly, or the percentage of answers for yes and no will change slightly. So let me just share my slides. So like what Anan has explained, I have a background in technology. I'm an engineer, and I've been working as a patent attorney. And I'm also having this role as an external expert with the Southeast Asia IP SME Helpdesk. So like what Benoit has explained earlier, there is a team with of people at the helpdesk that will be assisting you with IP queries if you are SME from the EU region. And they also work with external experts as well as myself, if there are very specific questions which they find that experts are better at addressing. So because we are talking about new technologies, patents is very much an important concept that we want to educate you about today and to share more with you today. And that's why I'm doing a presentation. So we'll skip this. I believe that the slides will be shared later to the participants, so you can always refer to the slides for more information. So very quickly, this is what I'm going to cover. I understand that some of the participants today have a background in IP. Some of you are in fact from legal practice, because we have the list of participants for this. But we know that some of you are perhaps business owners with limited understanding of IP. So I want to set the background for everyone to have a good understanding of IP before the rest of the presenters will speak more about perhaps a use case of IP and how it applies to perhaps their businesses. And then the second part of my presentation will be dealing with specific types of new technologies and how intellectual property can be used to protect certain aspects of your technology. As you can see over here, I'm actually focusing very much on digital technologies. So AI, machine learning, FinTech, blockchain, NFTs, the Metaverse. I have to say that there are many other forms of new technologies out there. In fact, today I was speaking to a client and they are in the field of alternative protein. So alternative protein, sustainable food production, all these are also new technologies. But today I'm focusing on this because there's a very specific part of patents for digital technologies that I would like to talk about. So basically, I'd like you to understand what IP is. We've been talking about IP, the title includes intellectual property. What exactly is intellectual property? So intellectual property arises almost every day because humans are creative individuals. You experience certain things, and from your knowledge, you create new, let's say, new knowledge in particular technology, new literature, new artwork, and anything that is a product of the human mind or intellect, which is new, is considered intellectual property. And for a business, obviously, this is very important because you're generating all these sort of intellectual property. It belongs to you. You want to make sure that you have proper ownership of this sort of intellectual property. So I've given you some examples. Intellectual property can be in the form of a technical innovation. It could be a song lyric. It could be a dance sequence. It could be business know-how. So it depends on the type of business that your company is in, and there will be different types of intellectual property that you and your colleagues are generating constantly. So very interestingly, when I introduce myself to some of my new friends, I'm telling them, oh, I'm an intellectual, I work in intellectual property. I am an intellectual property advisor. Somehow they only recall the word property. And so they think of it in terms of real estate. Oh yeah, property agent. Actually, there is some good because of this association. If you're thinking in terms of intellectual property, it sounds very intangible. You're not very sure what this concept is. You can actually think of it like tangible real estate property. It is an asset. It can be valued if you own it, and it can be sold, it can be transferred. And very often it's licensed, and you can make money as a business licensing your IP. So the next thing is for intellectual property, because there are various types of intellectual property. Well, we normally categorize them in 3 different buckets. So the first one will be registrable IP. The second will be non-registrable IP. The third group will be normally referred to as intangible assets in soft IP. So I'll go through that more in a moment. So conversely, besides intellectual property, we often talk about intellectual property rights. So intellectual property rights are rights, or in fact laws, that has been designed to protect a certain kind of intellectual property. And as a business, you actually should be focusing on identifying your intellectual property and making sure that you acquire the intellectual property rights that is relevant to the IP that you're generating. So with the acquisition or with the development of your IP rights portfolio, you are able to exclude others, your competitors, from exploiting your IP, which you are the owner of. So to make it slightly simpler, here is a diagram that shows you the type of IP rights associated with the relevant IP. So over here, you can see that patents, trademarks, designs, and copyrights, these are the type of IPRs, intellectual property rights, that you should be looking at and deciding whether you want to secure ownership of. So the rest are actually just the various associated IPRs to the IP rights. So for example, trademarks is used to protect your logos, your brands, and your product models. And for patents, it is commonly used to protect new technologies and innovations. Then of course, there's designs and copyright, and there are actually quite a lot of other types of intellectual property rights, but I'm focusing on this main 4, which is more or less what most companies should at least be aware of. So I talked about registrable and non-registrable IP rights. For patents, trademark, copyright, and designs, you can see over here, patents, trademarks, and designs are registrable IP rights. Copyright is a non-registrable IP right. What does it mean by non-registrable? It means that you have the IP right automatically. There is no need to register it with the IP office. And conversely, for patents, trademark, and designs, you need to register with the IP office. So for Singapore, if you are looking at obtaining a patent, you should be registering a patent. You should be first filing a patent application with the Singapore Intellectual Property Office. They will be handling your patent application. And if it is finally accepted, you'll be issued a patent certificate. So there is also this third category that I mentioned, which is a trade secrets, know-how, confidential information, the kind of soft IP. Why they are separated from the first two types of IP is because there is, first of all, they are not registrable. Secondly, the laws are not, there's no very specific law that governs trade secrets. Unlike for patents, there is the Patents Act. So there's a specific law for patents in Singapore. For confidential information for trade secrets and know-how, normally what happens is if there's a dispute or there's a breach, if trade secrets are leaked, then you go after the party through damages, this is through the law of tort rather than the specific IP laws. So for trade secrets, this is very common for every company, every business. There are certain things that you operate within your business that you do not want to reveal to your competitors, because revealing such information will be detrimental to the success of your business. So the examples are given on the left, formulas, test data, training data. Formula, this is the best example for trade secret is the Coca-Cola recipe. And that's one of these things. It's a formula which is kept secret. And the way to keep it secret, you could use contracts such as employment contracts. When new employees join your company, you let them know that they are not allowed to disclose trade secrets such as a formula of a particular composition. You are also, as a business, you should think about other ways of protecting your trade secrets through digital and physical means. So of course, you hide the information behind encryption. You have digital access to various folders, and then physically, perhaps certain information is kept under lock and key. And for trade secrets, if you are able to keep it as a secret, well, it can last forever. So I think the Coca-Cola formula is easily over 50 to 80 years old. So as long as you can keep it a secret and for long, trade secrets is one of the ways that you might want to look into protecting your intellectual property. So after all this information, what I wish to really impress upon you is that as a business, you are constantly generating intellectual property. These are intellectual property that is proprietary to you. And if they fall under types of intellectual property rights that require registration, such as trademarks, patents, industrial designs, you should be taking steps to register them at the relevant IP offices. And with the registration, you can then enforce your rights against third parties. And no party is responsible for reminding you to do this. It is your sole responsibility to first identify the type of IP that your business possess, make the correct decision whether to register them, or maybe perhaps it's a non-registrable IP, so you know that you already own the IP rights to it. Maintain your IP rights. This can be in the form of payment of renewal fees, because after certain IP rights are registered, you continue to pay certain fees to ensure that the lifespan is extended beyond the first initial registration period. And of course, the last part, which is actually the most important part, after accumulating all these IP rights, what do you do with them? You might want to enforce them. You might want to license them, you might want to commercialize them in certain ways. It is also your responsibility to identify third-party unauthorized use of them, and then to take the suitable and necessary actions. So now we've come to like the first half of the end of the first half of the presentation. We have a quick poll, and hopefully if you have been paying attention, you will know the answer to this poll question. I think we will give you maybe about 20 seconds or so to complete this, and we will review the answers, or we'll review the percentage of correct answers based on this poll. Trademark, design, patent, copyright, trademark. Okay, I think the results are shared, and everyone can see that most people have chosen C as the answer, and then a number of you have chosen A as the answer. So I'm glad to see that actually most of you have gotten it correct. So trademark, designs, and patents require registration. So for A, why is it not the right answer? It's because copyright doesn't require registration. If you want to go back, if you want to refer to my slides later, I actually do have a page where it says, it does show specifically between patents, copyright, trademarks, and design, which ones are registrable and which ones are not. Okay. So after I've given you this like basic background about IP, we want to know exactly how is IP used, or how does it apply to new technologies? And again, I've said we are focusing on digital type of new technologies. So the first subset of new technologies that I've identified is AI, NLP, natural language processing, machine learning technologies, and particularly chatbots. So we have the three main types of IP that I've listed over here. Actually, trademark will be also one of the types of IP that is applicable to chatbots. I've not put them in because it's a little bit hard to represent copyrights visually. So for chatbots, I'm sure all of you are quite familiar with them. Many businesses now want to use chatbots to allow the customers to access information quickly and I should say reliably. So if you are in the business of developing chatbots, very importantly, you have your GUI that is displayed on the mobile phone. It could be on a website. And I've extracted two different types of chatbots. And you can see that the designs are different. They are unique. And they do satisfy the requirements for design registration. And I've actually not explained what designs are. So designs are a type of intellectual property right that protects the outward appearances of product. So this was what the law was developed for a long time ago, because basically we were fabricating physical products in the past, but also now design rights do cover the protection of graphical user interface. So displays, non-permanent displays on machines, such as mobile phones, on websites. And if you are in a business that comes up with new, creative, memorable designs, you can look into protecting them under design registration. And so, of course, chatbot is fueled by a lot of technology, and technology is being protected under patents. So why I identified digital inventions for this presentation is because a lot of people, when they speak with me, they say that, oh, I thought software is protected by copyright. So they are right. So software is a new technology, and again, because many of these laws were developed a long time ago, they are actually the regulators, I mean the authorities are finding it hard to have a neat way to protect software. So the source code, the machine code of software is currently being protected under copyright, because there's no difference to it to, let's say, a literary publication in the form of a novel. So Harry Potter itself, as well as source code, is protected under copyright. And but another aspect of software can be protected by patents. The application of the software, a technical application of the software to be exact. And so, as you can see, these are various US patents that are pulled out relating to chatbot technology. And last but not least, there is trademarks, which I've extracted a number of companies that are in the chatbot business. And if you are a company, you want your clients to recognize you because of your company name, or because of a very modern logo that is associated with your company. And the way to protect it is through filing of trademarks. So as you can see over here, if you are in this particular industry, there are various aspects of your business that can be protected through IP registration. And of course, trade secrets is also applicable to this industry, because again, there are certain types of business processes that you would like to keep it a secret from your competitors. And you might not even want to file a patent, because filing of patents include a detailed description of what you do. And if you are considering filing patents, when you're talking with your patent attorney, you should be coming to a stage where you decide whether to keep a particular technology a trade secret or not. So that was also something I was discussing with my client earlier this morning. Very quickly, I'm going to go through two other types of new technologies. So FinTech, quite similar. It's more or less the same reasoning as for chatbots, because for FinTech, you have graphical user interfaces designed for the users to easily navigate through your solution. And as long as the design is new, you should look into protecting them under design registrations. There are also various patents that have already been filed and granted to technologies relating to FinTech solutions. When I did my search, I really found hundreds and thousands of FinTech patents being filed. So another thing which I didn't mention earlier, but if we are always talking about companies that should be aware of acquiring IP rights, to file IP rights, let's say to file patents if we develop new technologies. If you are also aware of your competitors' movements or activities, you should also be looking at the patents that they are filing, because who knows, maybe you are actually encroaching on their patents, and you might be at risk of getting a patent lawsuit from them, and then then you are unable to perhaps use the technology that you have developed, because it overlaps too much with the competitor's patent. So patents is good, of course, to acquire them, to file them, to have a patent portfolio, but also make sure that if you are in a crowded market, be aware of all the patents that are being filed by your competitors, and make sure that you are not encroaching on their patents. So again, trademarks applies to every industry, and again, all these are trademarks that are related to FinTech solutions. So the first two examples were for a particular industry. This is an example of a particular product itself. So you can see that the Amazon Echo Dot, which basically is a smart assistant, you have patents surrounding the technology behind it. So these three patents actually granted in US are related to Amazon's Alexa. And there are trademarks also directly related to this product. And you can see actually on the top left corner, it's quite interesting. The Amazon has decided to also trademark the color changes that appears at the top of their physical product itself. So you can be quite creative in terms of trademarking not only the name of your product, but also various visible uniqueness to a certain product. Then on the left, these are actual designs that has been registered by Amazon for the Amazon Echo Dot. And you can see that they have various iterations of their product. There's a taller version and there's a short version. So if you have different representations of your designs, different registrations are required. So I think we are down to the last two slides or so. For IP relating to blockchain and NFT, it's a lot to cover. So I'm actually just going to quickly say that blockchain, basically it is a technology. It is possible to file patents relating to blockchain technology, and I've listed 4 patents over here, which I've checked on the US Patent Office database. So if you happen to be in the industry of blockchain solutions, then patents is certainly one of the ways you can look into protecting your new solutions. In terms of trademark, of course, there's something for everyone. All industries have a brand name, have a brand, and you should be looking at protecting it through registration of trademarks. So in terms of NFT, this is really contentious. So one of the things we've seen for NFT is that there's a lot of money being exchanged for ownership of certain NFTs. And what I want to say is you need to be warned well in advance. What you get from purchase of an NFT usually doesn't come with IP rights to it. So my understanding is if you acquire an NFT, all you do is digital. You have a digital record of ownership of this blockchain representation of this product. So maybe a better example is that the creator of an NFT can create 5 different NFTs of the same thing. So over here you can see this is Bird 8, if I correctly remember, is one of the NFTs that became very popular, and it makes it's being transferred for a lot of money. As you can see over here, it's like 23.7 million. So for this very first one, the same creator can create exactly the same NFT again and resell it. And then you can have 3 different people owning the same design, but actually they are different NFTs. And so where does your rights lie? Your rights is really in being able to claim that you own this particular NFT and no one else does. So that's my very basic understanding of NFT. And on the right is actually just something I noticed on OpenSea, that some Singaporeans have came up with a sort of an inspired Bored Apes type of NFT and listing them on OpenSea. So it's Bored Apes, but they are appearing with Singapore background. So you can see that Marina Bay Sands is behind one of those two apes. So lastly, I think for the Metaverse, for IP practitioners, what we are concerned with is when you as a business want to have presence in the Metaverse, we want to know how to control and ensure that there are no infringements happening in the Metaverse. So I guess very simply, you want to think of it like, so there's the web presence and then there's the Metaverse. So if there's infringement happening on a certain website, or let's say e-commerce website, you can go to the e-commerce website owner and then say, oh, look, there is an infringement of our rights, please remove them. For Metaverse, because some of, there are more than one Metaverse and some of them have shared ownership, we are not sure if there will be a particular authority that we can easily reach out to stop them from, to stop unauthorized infringement of IP rights. Metaverse, similar to websites, if an infringement takes place, where does it take place? Because it all happens digitally. Because normally your rights, like what I said, if you file a patent in Singapore, your patent right is only restricted to Singapore. And if the infringement happens in the internet, how can you pin it down to saying that it actually happened in Singapore? And then you can file a suit with the Singapore court where there is infringement taking place online. So for Metaverse, similarly, we want to, it is still quite new, but we are all trying to figure out what's the best way to identify where exactly infringement is taking place, because there's no such thing as a Metaverse court for us to go to. Monitoring also seems to be an issue because websites, web spaces have been around for a long time. There's quite well-developed ways to review and to trawl to websites, e-commerce websites for infringements. But how do we do that for the Metaverse? I think perhaps there will be more solution providers coming out with solutions for that. And for existing businesses, if you are trying to expand into the Metaverse, maybe let's say if you're a luxury retailer and you're selling handbags, and so you have registration in certain classes. But when you're in the Metaverse, you want to perhaps sell digital versions of your luxury bags. And so we will be suggesting that these companies that routinely register trademarks in certain classes to look at other classes which are related to digital experiences and solutions. So class 9, 35, 41, well, 9 is related to software, 35 I believe is related to retailing, 41, I can't remember at the moment, but it's related to digital types of experiences that you want to perhaps seek protection in. Then of course, because let's say your trademarks used to be a 2D type of trademark, because of the Metaverse happening in the 3D space, you might want to look at protecting certain trademarks or designs in 3D or in movement or motion sequence, rather than just a flat 2D representation. So thank you so much for your attention so far. This is the last slide. I hope you understand that when there is a particular business or particular product, which I use the Amazon Alexa Echo Dot as an example, you can have multiple forms of IP rights tagged to a particular product. And then you should look at protecting them by registering them. If you are seriously considering acquiring of IP rights, you should be allocating a budget for it, and also be aware that enforcement can cause quite a big dent into your budget. You should speak to an IP professional during the early stages of your business. We will always be advising you to file your applications as soon as possible, because you never know, perhaps somebody else down the line or down the road came out with the same concept, came out with the same brand name, or came out with the same design, and perhaps registering before you. And registration follows on a first to file basis. So the first registrant has the rights to that particular IP. And then, of course, after this presentation, I hope you understand there are different types of IP rights, and certain ones are suitable for certain types of IP. And then after securing your IP rights, you should also monitor for infringement. So thank you so much again for your time, and I will stop sharing my screen and let the rest of the presenters have their time for the afternoon.
Thank you, Yeng. That was really very nicely detailed and fascinating. It was so good that questions have already started flowing in. And I will say that I forgot to mention at the start, if you have questions, please send them in to us. I think there's a Q&A box, maybe even a chat box. Send them on to us, and following the third presentation, we will have a Q&A session where the panel will be discussing some of the questions you have posed, as many as we can try and cover in the space of time we have left. So that brings us nicely on to our next speaker, who is Dr. Tom James. Whenever I see somebody with a doctor in front of his or her name, I'm really impressed, and we do have another doctor that will follow afterwards. I hate studying, so the idea of doing a PhD just blows my mind, and I really take my hat off to these guys. Tom is a charismatic speaker. You will be impressed, I believe. He is the CEO and CIO, co-founder of TradeFlow Funds from TradeFlow Capital Management, and he has over 30 years of experience in this space of commercial exposure, and he's been called a serial entrepreneur in the FinTech space. And he will have a lot of interesting stuff to share for us this afternoon. Tom, I'll hand it over to you.
Thank you very much. So, yes, good afternoon, everyone. Good evening, good morning, depending where you are. Good. So you've heard some very, very good overview of IP, copyright, other applications. The interesting thing is the commercial side of things. So I'm coming very much from someone who has to register IP and has to look at the pros and cons as highlighted, between sort of the Coca-Cola recipe example we had there, versus actually showing the world what you're doing and going for sort of public patents, etc. So hopefully this will be coming from a slightly different angle. To give a little bit of context, our company, TradeFlow Capital, is a bit of a hybrid. So we're a fund manager regulated by the MAS, but at the same time, what we do is only possible thanks to new technologies. And it's important, we've had a journey over 6 years now of having to go through the logical choice, as described by the previous speaker, of do we need to register some IP? Is it core to our activities, or do we somehow protected in other ways. Yeah, we address the trade finance gap. That's what we do. The gap here has basically developed as the cost. Usually, the cost for banks has increased to be able to look after the smaller sized firms and their import and exports of commodities, sometimes merchandise. And so we looked at this trade finance problem back in 2016. And the reason we ended up sort of going into FinTech and having to look at the whole issue of IP was because the answer was, why banks were not lending to the SMEs was a lack of data, primarily, lack of transparency in those transactions. And so as a result, we had to look at digitizing the process of, onboarding a customer, looking at their know your customer requirements, anti-money laundering processing, making sure that people were who they said they were, and then being able to conclude transactions digitally all the way through to the final tracking of cargoes and payments. So a huge amount of technology, some of it owned, some of it white labeled, some of it developed, and some of it open source. So quite a complex sort of IP makeup. Next slide, please. It's worth the effort. Obviously, it is a bit of a minefield around IP, and importantly, protecting it the right way. So it is good to get good commercial and legal advice over that. As we heard from the previous speaker, a lot of it can be covered sometimes by copyright. But again, I think from a commercial perspective, it's, if you're relying on copyright, you just got to make sure that you document things properly and also somehow have a repository somewhere to deposit that. So you can prove that, I was using it or I wrote it, and here's proof when, so from which date you had been utilizing those marks or code, etc. So there are ways of doing things, but get good advice. We've certainly seen huge benefits in our business, so it is worth the investment, worth the effort. Certainly in our space with digitization and applying lots of new technologies, lots of benefits for the trading community who are moving commodities around the world, and here in Singapore is obviously a key hub for commodities. So it's been a very important way to progress the ecosystem and help make sure things get properly funded. Next slide, please. So what sort of technologies are we talking about? Well, again, we've had to look at using artificial intelligence. We use GPS. We use the cloud, which was also another key thing of security around the cloud and your IP from the software perspective of things there as well. Robot process automation as well, RPA. Again, your data may be going through lots of third-party services, and you've got to look at I think there was one very interesting case where we were looking to utilize a third-party service provider to process some data for us. And suddenly, when you look through the details of the service agreement, we realized that they ended up taking ownership of all the data resulting from their processing, which suddenly means that our proprietary data is no longer proprietary. So there's you have to, certainly from the technology perspective, really look into the detail of any contracts, because data is the new currency, right? That's what we're told. And I think that's also very important IP and certainly important asset to control and the ownership of. And, more importantly, if you're processing people's data or sensitive information which might fall under GDPR or other types of data protection acts, you've really got to then know what you're doing and get good advice on that. But that's, we live in the world of outsourcing, and that has added another level of IP protection complexity, which we must be cognizant of and take a look at. Yeah, so that sort of comes into the big data processing, etc., and making sure we have the right controls and ownership of data that has been processed by third-party processors. It may look, a lot of free services mean that there is a catch. All the data that you put in their free service, suddenly they also have maybe not ownership, but the full rights of usage. And I will come on to that in just a moment as well, in terms of the ownership versus usage rights, as that's also an interesting challenge around the IP controls of things. The other interesting thing is that as we're using more and more of the cloud, what is interesting to note is that, probably, certainly, I work in and around technology, but I was also very surprised to learn that probably 90% of most applications, so computer software applications that people use, have some third-party components inside them. In fact, mostly what we call open source. So certainly if you're, I think there's very few businesses around anymore that don't use some form of computer systems, software, and probably also have modified or improved that software potentially. And that is another point which I will come on to in a moment as well. Next slide, please. So, these are the sort of key challenges for a business user, being in the field, is the challenges of, well, I'm taught in business, I want to build value for my shareholders. Through building intellectual property or building some assets, also tangible and intangible assets, into the balance sheet. But as I just mentioned, in fact, large percentage of most applications and software that people are using consist of some third-party components. These days, so much is done on this open source basis. And in fact, there's some reports out which I was reading recently that actually showed 50% of the global 500 S&P have open source components in their systems and software. And in fact, this is a new service, a new whole industry that has been created as a result of trying to isolate intellectual property within source code. And there are firms and consultants who can analyze the code in your software and identify what is open source and what is yours. So open source is typically the sort of crowd-sourced, developed within a large community of programmers. A lot of people like open source software or code because it's typically been looked at by so many people. A lot of the bugs and problems are fixed. And so you find these days in software development, it is very much component-based, like a jigsaw puzzle. And a lot of these bits of the jigsaw puzzle can be reused and are reused and reapplied into many other projects. And so you can suddenly find that in a large company that, when you analyze your code, you suddenly find that lots of your applications may be reusing bits of open source. So, I would strongly recommend that if you are doing any development work or any enhancement of software to tweak it, to make it useful for your company, at the earliest opportunity, start to actually build a database or analysis of the open source code that is being used by your organization. You can use open source, but there are sometimes usage terms or recognition that has to go to the coders of that. Or if you modify that open source code for your own particular use, you may have to also copy that information back to the community as improving it. And there's also then trying to identify what is your effort and your IP and what is open source. And that is very important in a business. If you're trying to sell your company or do anything, you're going to have those sorts of details so that you can clear the sale of your business or IPO of your business, etc. So it's very important there. In terms of the challenge is, well, you need your business to work. You do want to have as much IP as you want, but also sometimes it's certainly more cost effective to just use open source data and modify that as it's working. So there's the commercial angle as well of, do I really want to build this from scratch so I can own it, but it's going to cost a load of money? More importantly, it costs time. So there's always that balance of creating IP in the first place or licensing or white labeling stuff and then improving it. Certainly our experience is that we have been able to take source code of particular applications, package that with lawyers, so you have a disk of that original code. So there is a screenshot of what it was like, and then having an understanding and a license with the owners of the original code that anything you do in addition is your code. And so it is possible to speed up development work there and still own your investment in that software and the development of particular additions to that software. And typically, we're not registering that IP, but it comes under, as to the previous speaker was talking about, trade secrets, keeping that code and information proprietary, keeping it within the company, and like Coca-Cola does, making sure that all your programmers and staff are signed up to non-disclosure agreements, and also for programmers, explicitly ensuring that anything they are developing for you, is your property, is your IP. So again, that's a very important thing around employment contracts. And I think the previous speaker alluded to that, to make sure that you have the proper wording in there, particularly for people who are building code or building software and new technologies for your company. Otherwise, potentially they can walk off and then reconstruct your code somewhere else, and suddenly you find that you've sponsored a competitor. So lots of management controls and thought processes there to do. So on my slide here, I've also mentioned rights of use versus ownership. So this is the other interesting thing around the IP and new technologies. With case study, case in point with Singapore Institute of Technology. So We've had a wonderful relationship with them in Singapore, also supporting their students for work-based training with us, but also working with their lecturers and their development teams. And now with their research teams, we have an ongoing artificial intelligence research project in the area of shipping, which we announced earlier in the year. And there again, we have to work with a specialized licensed agreement. So, we're both contributing to the project. They're providing certain resources, we're providing certain resources. They're doing a lot of the coding work. They, own IP, but they license it to us for our use, for perpetual licensing, for applications in our industry. They want to be able to reuse code and stuff that they develop with us for educational purposes. So again, you're able to sometimes find a great collaborative benefit around how you structure the ownership versus the rights of use and of IP which you jointly develop. So there is a lot of flexibility around there. So I guess my value added for today's discussion really is around yes, new technologies, new developments, cutting edge stuff with AI research, but from the commercial perspective, you have to think through, do I need to own it, or do I just need to use it? Can I joint venture with someone else? Can I take some existing code and build on that if it's with a particular company? Do I use open source? But if, as I said before, if you use open source code, it's worthwhile databasing and making sure you know what is being used, what components are being used in your business, because you will have to differentiate that when it comes to either valuation or auditing of your firm, and also to ensure compliance, because incorrectly, many people have the understanding that, oh, it's open source, it's free, I can do whatever I want with it without any reporting. There are actually typically usage terms for that code, and you have to, if you improve that code or you fix a bug or problem in that code, you need to share that back with certain programming communities, etc. So you want to make sure that you're compliant within the software community there. Okay, hopefully that gives a slightly different angle on things. And so I will stop there. Thank you very much indeed.
Thank you, Tom. I was going to say that's a nice balanced discussion, which is a nice balance between what Yeng shared and what Tom just shared. From a practical perspective, I think some of us, whether you're in the industry or as lawyers, a lot of things you need to think about, when you sign your agreements, when you negotiate terms, like, the stuff that Tom has shared, I think gives us a lot of food for thought in how you negotiate some of these terms about ownership of IP and what happens next. So thank you, Tom. That was very interesting. Okay, we move on to our third speaker, Dr. Tara Prasad, another PhD holder. And she's from Tata Consulting Services, the corporate IP and engineering group. And she has a lot of experience dealing with IP issues, and she guides the teams in terms of IP creation, IP protection, IP portfolio management, landscaping, searching, FTOs, and a whole suite of stuff. She's got an interesting talk for us as well. So without further ado, I'll hand you over to Dr. Tara Prasad.
Yeah. So I'm sharing my screen. Are you able to see?
Yes.
Okay, so good afternoon, everybody. Good morning and good evening to others across the globe who have logged in. So I think both the previous speakers have already set the ground, and they have spoken about the different types of IP and the ways of some of the ways of protection on the mainly from the open source front. I'll be from the business angle. Many of those what Dr. Tom spoke about, we as a part of our software asset development, we take care of those compliances, which I'll be talking about. Before that, what is Metaverse all about is what I just wanted to speak a little before I move on to, from the TCS perspective, what are the things from the IP angle we take care. So Metaverse, in short, this is one of the most happening now. It is a coexistence of physical and virtual reality. And there is no standard definition of Metaverse as such. If you see meta and verse, so it is kind of beyond the universe is what they call, where there is a coexistence of physical and virtual reality. So there are three key aspects in the Metaverse space. One is on the technology, that is the technology that enables the digital content to lay over the real world. That is similar to the augmented reality, what we talk about. And the second one is on the Metaverse applied to the hardware device that enables the real world to be interactive. And then the digital content is applied so that the user using this device, they can control the device and then get all the real world displayed virtually and also interact. And the third aspect is about the information now. It is about everything and anything. So you have the real world and you get the user's information through over the internet, what their habits are, what their schedule is, what their locations are. Okay, you get all of them through internet and machine learning. You get the real field, and then there is a most interactive things happening from the user accessing the real world over the virtual space. So these are the three things about the Metaverse. That is where that coexistence of physical and virtual reality comes in. If you see the Bloomberg Intelligence, they predict that global Metaverse revenue could exceed USD 800 billion by 2024. So going to what are the opportunities in Metaverse? One is on the Metaverse as a destination, and the second one is Metaverse as a system. So Metaverse is a destination. What it is, if you see in early 1990s, the search engines like Google and Yahoo, they crawled through the web and then they were focusing on the attention to the ads. So that is a new business model which has developed. But then in the Metaverse, that is basically the employee and the customer strategy is what is going to emerge. And that is what is happening in many of these business companies, where the retail side of it, or the telecommunication side of it, or any business, if you see the life sciences, the drug discovery, all of them, how the customer and employee strategy, how they create and how they make it happy is what is being thought about. And Metaverse is a system. It is a very complex adaptive system. And some of the examples here I've just listed. One is on the Hong Kong International Airport. They are working with this Unity team to build a Metaverse to simulate the world. And similarly with the Boeing also, they are also using Unity's help to see how they can replicate the digital twin replica and then run some simulations. At TCS, we as a part of growth and transformation strategy initiative, that is one of the key initiative for us, other than cost optimization. One of the key theme for us is customer experience. So we have continued focus on strengthening and deepening this relationship. And one of the things what we use is, in addition to the omni-channel journeys, immersive device diagnostic, that is XR, VR, augmented realities, one of the other important focus area is on the augmented reality, the extended reality and Metaverse, and hyper-personalization. That is how we can improve the customer experience is what is the key focus. And we also have the TCS, one of the TCS IP codes for market. All these are available if you go to our integrated annual report, or also we have for codes, we have a separate website on tcs.com/codes. So codes for market is one of the very important IP for TCS, which is developed on the blockchain technology, mainly from the leveraging the multiple assets, including the equity, fixed income, NFTs, loyalty points. All these are being developed as part of this TCS IP using the blockchain technology. So coming to the IP, what the different types of IP, what Wei Tang has mentioned about, for us, TCS, we have grown past right from 1994, we have been filing patents. If you see 1994, our patent filing journey started, but now we have about 6,000 plus patents filed across different technologies, different subject clusters, out of which about 2,000 patents have been granted, which have been backed by for the different IP assets what TCS has developed. So the main criteria of patentability, what we go is by the guidance as given by the European Patent Office. We focus on the application of problem solution approach. So we see what is the closest prior art of the invention, and then assess the objective technical problem to be solved, and then see what are the claims we can take out based on those prior art and then objective technical problem. And then we strategize how to solve the technical problem. Again, we see what are the features, we separate out those features and see what are the technical element in that, and then draft the patent. We also have an in-house framework called Collaborative Invention Mining Framework, where that is used to mature the idea from the inventors, where all the inventors from the various business units, they approach us. We are a small intellectual property and engineering group, the corporate group in TCS office. So the business units, when they approach us, if the idea is still nascent, to have this problem solution approach and the technical problem to mature that invention to that aspect, we use something called collaborative invention mining, which kind of matures the idea right from the original nascent idea to the patent-worthy filing. And on the copyright aspects, as Dr. Tom was also mentioning, some of the best practices we follow is reviewing the agreements for distribution of third-party content for proper licenses. We also use various third-party softwares as part of our asset development process. So we have a very detailed process of how, once the third-party software is procured, what are the terms and conditions, what is applicable to us. As Dr. Tom was also mentioning, we should not be in the sense that we use a third party and then when we kind of merge our software code with the third party, then it, as per the terms and agreement, then our proprietary code is lost to the third party. So all those checks and balances, we have a thorough process and guidelines and checks in place. We also use for open source, we use a licensed tool called Palamida. Earlier we were using Black Duck to scan all the open source, what is being used for the software development, and then see what are the commercial, if there is a general purpose license where we have to, if you have used those kind of open source, which amounts us to give back something to the society, we refrain from using those, and then we use only the Apache and the free softwares which we are supposed to use. So again, as I said, we have a very thorough check in place. So the thing what we follow is the right access and right usage, and ensure that none of these, we are all compliant as part of our asset development. And we also have a very detailed process of any of the copyright, the code copyright. We have a database where we register, and then we have a database of all the softwares, whatever we have developed, so that tomorrow, if there is any kind of litigation comes, we can prove in the court of law that these are our copyright, what we have developed, so that that is available in the database. And on the trademark also, what in the previous presentation, what Wei Tang was talking about, many of the trademarks, what we have for our TCS IP assets, we register it in the class 9, 35, 41, 42, which are all applicable as part of this for the TCS IP assets, so that we are we ensure that there is no infringement kind of cases or no litigation. So some of the points what I want to ponder as part of our these emerging technologies, and especially from the metaverse. This is just a point to ponder, because metaverse is still a new thing which is happening, and a lot of things from the law and regulation perspective one needs to take care before it is fully formalized. One is, since everything is digital and virtual, and the virtual space is created, then who is the creator? What data was used for creating? Who owns the data, right? Who is the owner of that IP? Who is, if the persona, the created, what is that virtual persona, is that liable, or who is the infringer? And suppose in the metaverse, somewhere in one jurisdiction we create something, but then it is commercialized in other world, other jurisdiction. So what is the jurisdiction of rights? And for NFTs especially, how the transactions are getting recorded in patent office, and kind of confidentialities, how we manage the confidentialities when NFTs are used. And from the data privacy, again, it was also previously discussed, how we capture, how we protect the data privacy. So these are some of the things we need to ponder, and then these are open discussion points. I think that's it from my side, since many of the points were already covered. I'm just talking from the business angle, how we also manage and ensure that we are compliant to whatever software assets we build by filing the necessary patents, copyrights, and trademarks, so that when we go to the market, we ensure there is a risk of, mitigate the risk of infringement. Over to you, Anan.
Thank you so much, Tara. Yeah, she referred a lot to the metaverse, and that's a new area that we're all trying to grapple with. And if any of you watched Doctor Strange Part 2, you know, there's this thing called the multiverse. So I think the headache that's going to face all of us is, where do we sue in the multiverse, right? Which universe do you have to go and find the right court to sue in? But anyway, so we've reached the session where we, I guess we have a couple of minutes left for Q&A. A couple of you have put in some questions, and maybe I'll jump straight onto those. The first question that we have, I think, is probably best for Yeng. So the question is, when we use designs to protect the graphical user interface of softwares, which features are actually protected? Yeng, can I throw that at you?
Yeah, I think actually, when you make a filing for the registration of the design, what you do is you submit images of the design they are seeking to protect. So I guess my point is, if you want to protect the full screen GUI, then that is what you'll be submitting to the IP office. And the IP office will grant you the right of it as a design as a whole. If you are perhaps, maybe sometimes, let's say you perhaps design some emoji. So there's a specific component of the GUI. You can also protect that by listing it, by having a representation of that GUI, and then filing it with the IP office. So what features are actually protected really depends on what is being filed with the IP office. Quite interestingly, you need to specify what the design is applied on. So you will have to say this design is to be applied on mobile phones or particular interactive technology. So there are various ways to categorize what you're trying to protect. And then, of course, representation of exactly what you're trying to protect. If you are able to access some of the IP databases, there will be lots of examples that you can find. So one of the things that we talked about, when you file registrations, all these eventually become public records. So you can always access and see, let's say, what Tata has filed and review them. And you can, and that's how I got those various designs for my presentation too. So I hope that explains how designs are protected and what aspect of it is being protected.
Yeah, and I guess just to add on, I mean, there are user interface software patents that have been filed. So that is another way you can seek protection. The only problem is it takes a longer time to get it protected. And I think, as Tom was mentioning earlier, some of these things, do you really want to file a patent and disclose to the whole world? If there's a lot of explanation as to why you have this graphical user interface and the scope of protection, because sometimes technology moves so fast that you may not want to seek protection for something that may take 5 years to get protection for. Although in some countries like Singapore, we do have a fast track system. So every year there are a couple of patents that the Patent Office will allow under the fast track scheme. So that's something that, in a country like Singapore, you can consider to hopefully get a quick patent grant. And that may protect more than just the design, because as Yeng's correctly explained, the design protection is basically for the designs as per the drawings you submit, whereas obviously for patents, you've got all your claims and a broader description of what gives you your protection. Thanks, Yeng. Okay, so I had a question for...
Sorry to
interrupt.
We just need 30 seconds, then I'll just go back to just launch again the poll. And then I just hand it over back to you. So it's just the two same questions from the beginning, just 20 seconds to see if the results are different. And then, yes, there are still a lot of things to discuss. So sorry for the interruption.
No problem, no problem.
The first question: in Singapore, I can register my copyright before the Copyright Office. It's kind of tricky. And I saw that most of the people had said something that, well, maybe we can explain later. And the second, new technologies using artificial intelligence and machine learning can be protected by IP, true or false? Just 5 seconds more extra to answer. Well, at least the first question changed. Yeah, so well, maybe we can discuss if we have time about this question. Just go ahead with the other.
Okay, thanks, Benoit. Yeah, we will come back to that poll. Quick question for Tara. Infringements in the old days, in the 90s, we used to have physical infringements. You used to go to shops and raid, fake watches and fake T-shirts. And then over the course of time, people sell stuff online, and now there's a lot of infringements online. But today, even the online infringements have moved into a different sphere. You've got all kinds of new technologies, as we've discussed today. So the question for you, Tara, is, have you come across the sort of new technologies that you have to deal with online, and how do you deal with such things?
Yeah. Yes, thanks, Anan. As I was talking about, we have a lot of TCS IP in the retail space, where we use a lot of these open source technology, and then a lot of this IP has many of these features pertaining to the retail. So what we do is, as part of our asset development, right from the conceptualization phase, when we do the market research, when we study what are the features this asset has to be developed on, we do a thorough market research and see what are the differentiating features. We do a landscape study and then see what are the gaps, come out with the differentiators, file certain patents backing those differentiating features. Okay, and then as part of the asset development, when we use the softwares, if you are using a third-party software or if you're using the open source, as was even Dr. Tom was talking about, we do a thorough scan of what we are using from the net, from the open source, so that tomorrow when we deploy the asset to the market, we don't run into the problem. Right? So we have a thorough scan done. In case any of them are not compliant, then we ensure that that software code is taken off, and then we use our own proprietary code in that place, and then before we deploy. So that is called IP safe assessment. Before we go, the thorough engineering check is being carried out. And also once it is deployed, it is not that open source, there is also the term validity. It can be that the open source, the terms and conditions says today that it is open and it can be used. But maybe after 6 months, they would have changed the terms and conditions altogether. And then they'll say that it is no longer open source, right? So in that case, again, we might run into infringement. Okay, there is a risk. So we ensure that every 6 months, thorough scan is done. We have a team which monitors what are the licensors' terms and conditions for these open source, so that we ensure that we are compliant before we go to the market.
Okay, thanks, Tara. Quick question for Tom. And this has to do with funding incentives here in Singapore, because you're obviously familiar with the landscape here. Just a quick question on whether there are sufficient incentives, financial assistance made available in relation to the creation, development, and protection of new technologies here in Singapore. What are your thoughts?
Yeah, it's an interesting question. I mean, there's certainly MAS grants, Enterprise Singapore, IMDB, and many others who can give a substantial amount of support for the adoption of new technologies, as well as in the development of those products as well. And I understand that if you put, don't sue me on this, but I understand from that you can, if you've fully developing a product, certainly under some of the Enterprise Singapore schemes that I've seen, that you can include in that budget some costs towards your IP protection. So it's, I think it does vary quite a lot, but I think it's definitely worth asking, and I think there can be financial support for that. There is for the development of things, but I think also there's a good argument there to include some recoup of costs to protect that, particularly to keep that protected in Singapore.
Okay, thanks. I mean, just from our experience, I mean, the government here is really trying very hard to encourage, foreign parties, especially, so Europeans, Americans, and so on, to come here, set up shop, do the R&D. So there are considerable incentives made available. And I think Benoit and team at the SME Helpdesk will be able to, hook you up if you have questions, or if you have need to be synced up with relevant government authorities or other bodies here that do provide financing in that sort of space. I have one last question that I will throw back at Yeng. There was a discussion on Amazon's Alexa trademark that is a lightning pattern. Is this registrable in Singapore? And if so, what kind of representation document needs to be submitted? Yeng? You are muted.
Might be a little confusing, but the the documentation is quite similar to what I said earlier for designs.
Right.
So for trademarks, you can protect words, you can protect logos. So in this case, the lighting pattern more or less fall under a logo, because it's basically a drawing or a design. So when you the Singapore IP office, as well as most IP offices around the world, will accept registration of such logos. And all you need to do is to provide us with the representation of the logo. In Singapore, we can file trademarks digitally, so we just require a digital representation of that. And we need basic information like who is the applicant, the address of the applicant, and very importantly, you need to identify in which categories of goods and services that you would like to be protecting this particular design or logo with. So there are 45 classes, categories for trademarks. And if you work with a attorney or IP advisor, we can help identify the relevant categories to be registering them, and then also to work out the actual description of the products and services that you're for this design for registration. So this is kind of similar to what I was saying, and also what Tara was saying. There are different types of categories that are quite relevant to Metaverse. So for Metaverse, we look at categories relating to digital services. So that will be more in classes after class 35, between class 35 to class 45. So yeah, I hope that addresses your question. It's actually quite straightforward. When you want to file a trademark, first of all, you need a representation of a trademark. It could be a series of letters, words, and it could be some logos, some designs, which is similar to what this Amazon Alexa's lighting pattern is. It could be also a combination of both.
Okay, thanks, Wayne. I'll hand you back to Benoit for a minute to conclude the poll issue. Benoit?
Okay, well, very, very quickly. I'm happy because I saw a complete change for the first question. Basically, most of the people were answering that you could register copyright before the Copyright Office, but it's false because as of today, there's no Copyright Office in Singapore. Same goes for Brunei, Myanmar. Well, I don't know why. There must be some explanations behind. And as it was pointed by Dr. Tom James, most important for copyright is to have date of creation, all documents, evidence. But yes, this also to remind that even in Southeast Asia, all IP landscape, all IP regulations are very different, and you don't have the same options. So just, it's a matter of raising awareness and getting some knowledge, and you can always have a look or have publications available on our website.
Okay, thanks, Benoit. There was a last minute question that just dived in. I'll just take a quick stab at answering that question. It's about trade secrets. I'll read the question. The government has been driving industries to change their product formula to be healthier, etc. Do you see this as a potential concern from a trade secret protection perspective? So just my 2 cents worth, and any of the panel members can jump in to correct me. At the end of the day, as long as you're not disclosing it and not required to disclose these formula by the government, then it can remain as a trade secret. You just need to tweak what you're doing, but you keep it to yourself. And trade secrets, as long as you keep it to a small group within your organization and make sure that it is treated as a secret and not just shared with everybody at large, then it's still protectable, But the minute you disclose it and if you have to put it on labels, fair enough, then that's where you lose that protection. But otherwise, you can still keep it secret by not having to disclose all the key stuff, but keep most of that to yourself within a small group within your organization. So just 2 cents worth. I know we've run over time, and I really just want to thank everybody for staying on as long as you have. It just leaves me to thank everybody that's been involved with this webinar. Thank you for Eurocham for putting this together, and for everybody behind the scenes who have really worked tirelessly to make sure we all, have this presentation on today. And 3 speakers, thank you each of you for your time and your great presentations. And thank you, audience, for your involvement, for staying on, and for the questions as well. Anybody from Eurocham have a final word? Benoit, I'll leave you to close.
I don't have anything special. I thought there would be remarks from Eurocham Singapore. But well, thank you very much for moderating the session, and thank you for all the speakers. Always nice to see IP connected with everything that is new. So IP is connected with everything in the end. Yeah.
Yeah.
All right.
And wishing
Thank
a
you.
great day, great evening, great everything to everyone.
Yeah.
Thank you.
Thank you.
Bye, everyone.
Bye.
Bye.
Bye.